I'm Pavla Vackova. I'm a lawyer and attorney at law from Czech Republic, Prague, and I have a practice with a focus on family and business law, and especially with international element. And since a couple of years, I see in my practice like a strong influence of Ukrainian clients and of course of families that are international, whereas like some international element present. And with this, I started to reach out to my Ukrainian colleagues, especially to Olena Максименко, the head of UNBA in Czech Republic, because of course with these clients, I need to understand where they come from and what is the law that they understood, like what is the law system that they understand, because they might have completely different expectations towards the Czech law. And since I'm very much focused in my practice in the international practice and strongly on family law and especially international family law, I know that in order to be a better lawyer, better attorney, and in order to provide better service is always core importance for you to understand your client. So where I was is like that it's good to understand your client, and especially if you have this cross-border cases, then definitely you will need cooperation and a little strong knowledge of the law of the other country. So that's why we had the idea with my colleague to have a lecture on introduction of Czech family law. So maybe you can understand, you could understand better. And if you have a client, sometimes you even have this choice at the beginning. So maybe also for these kind of cases, it's good to know a little bit about the law of the other country. So because if I had to introduce Czech law, Czech family law, I would be here. I could be here for hours. So that's why I just chose some points that I kind of focused on. And basically it's children's custody, visiting rights, and alimony. Then divorce of marriage, division of property, and I mean division of matrimonial property, and a little focus, a little introduction into the Czech-Ukrainian treaty on the help in civil matters. And I will just introduce the part of it when it's focused on the family law. So what's going to be missing, and what's maybe these four areas are the most common that I have in my practice as a divorce and family lawyer. And what's going to be missing is the international child's abduction, and then preliminary decisions. So that would be maybe also interesting, but since these are very vivid areas of law, and it's like the practice almost in every case is a little bit different. So I would maybe share that if we have some other lecture. So let's continue. I practice that we deal the most often with sources of law. You have to know, the numbers is the numbering that we have in our Czech law system, but then the name of the convention, it's like in English, so you could all identify well these sources of law. So let's go to the next page. So, and this is maybe a little bit more interesting for us now, what I'm gonna show. So, the bilateral agreement between Czech Republic, that's the one that is most important if you have the Czech-Ukrainian family case. And here is the introduction of the most important laws in Czechia that you're going to deal with if you have a family law case. So a little heads up, we don't have law on family. So since recodification in 2014, we have this family law part as a part of a general civil code. So there's like the part that with family law. So, yes, sorry. So now, how does it work in Czech Republic when you deal with children's custody and alimony? So the things could be quite, when it comes to the rights of children and parents towards the rights, it doesn't matter if the couple was married or not. But legally, if there is a divorce or just a breakup of parents that weren't married, that's quite a different thing, because according to Czech civil code, if you want to get divorced, first you have to deal with the rights of children. And when I'm talking about children, I will mean minors. That means under 18. So if there is a divorce of a marriage where are minor children, then first you have to set the custody and alimony for the children. So if this is not set, there won't be no divorce. So as the state is right now, within divorce, you have at least 2 claims. So one claim will be about the children's custody, and the second will be about divorce. So, and you don't have to separate the matrimonial property. You can make an agreement, but you don't have to. And then I will talk about this a little bit later. So basically, if you cannot find an agreement between you two, you will have up to 3 claims just regarding one divorce. But starting next year, there will be a novelization of the law. So in case if there's a so-called negotiated divorce in Czech Republic, you also have to go to court. You still like there's no possibility of administrative divorce. But if there's a negotiated divorce, it means the parents, they agree and they have their agreement regarding children's custody, alimony, maybe visiting rights, and they agree both on the divorce. They could have this one settled within one proceeding, within one claim, within one visiting of the court. But this is something that I never experienced. As I said, the novel will be since January. So now, as it is right now, you definitely will go through a proceeding regarding a child, regarding children. So these claims are exempt from court fee. So, of course, if you are an unmarried couple and you want to set the rights for children, you also can have either a normal agreement, but if you don't agree, you also have to claim at the court. Yeah, so this proceeding is the same no matter whether the couple, whether parents were married or unmarried. So there's no fee. And like maybe if a client comes to you and shows you some paperwork from Czech Republic, you can just look at the file designation, and if you will see the file designation that it starts with P or NC, that would mean it is something about minor children. And usually it's about alimony or the custody or visiting rights. Usually all these three in one claim. So the jurisdiction, when it comes to the child, it's based on the child's residence. And the court should solve these cases with priority. What we can see that a little bit in our practice, that these children's matters are solved a little bit faster, not a little bit, sometimes a lot faster than the cases in normal civil matters, or even when it comes to divorce, that takes a longer time than the solving of child's custody or alimony. So until this December, the court always has to set, in the judgment, if there will be exclusive care on one parent, or the alternation of care, or a joint care. So after December 2024, this will not have to be set in that judgment anymore, but basically, as I imagine this will work, the parents will still stick to the old customs, and they would ask for the visiting rights to be somehow defined in the judgment. So this is very usual in a judgment on children. Usually you ask to specify the custody. So if the custody is exclusively goes to one of the parents, so or if it's alternation of care, or if it's joint care, then you want to have the visiting rights of the other parent. So for the exclusive care, the most common is the child is in care of the mother, and the father has the right to have the child every other weekend, from Thursday sometimes, or from Friday until Sunday morning, or he will give the child at Monday to the school. So this the usual for the exclusive care, and then you have like 50-50 split for the holidays, and alternation for holidays like Christmas or others. If it's alternation of care, so there will be usually division of the time that the child spends with one or the other parent, 50-50. So let's say 14 days of a month with father and 40 days of the month with mother. And then, of course, you split or alternate the holidays. With the joint care, that is only usually set if the parents agree on it, and if they have if they are in good terms. So these visiting rights will not be set there. The other sorry, thing is that the parents have to live close together. So that means in one city, and usually the children are a little bit older, so they can really call themselves and set it, so they don't need this exact judgment where these times will be set. So it's quite free, but it doesn't happen very often. So, what is the judicial outcomes that the Czech court operate with is that usually they will evaluate if there is obstacle to alternating care. So they have a strong focus on the parental right for the child, and the child's right to have both parents in their life. So usually the courts, they had for the division in alternation care, like even for very small children. And they really want just strongly, there will be also the other parent, often the other parent will often see the other child. So these are the types of cares. So we can go to other post. So what will be here with the novelization? Nowadays, I forgot to say that within this claim, there is a mandatory representation by the child social and legal protection of by the Office of Child and of Protection of Child. Yeah, so the abbreviation in Czech is OSPOD. So in case of a consensual divorce, there will be no mandatory child representation anymore. And of course, there will be higher fee for unagreed divorce. But still, if you only claim regarding the children, there is no fee. So, how to determine the child support, maintenance, alimony. So I will use these terms and they mean all the same. So the alimony should be defined and should be set according to the child's needs and according to the income of the other parent. So usually the alimony pays the parent that has not the child custody, that has not the exclusive child custody. But in case of alternating custody, so in case that the child will be like, let's say, 48% of the time with the father and 52% of the time with the mother, usually the court will have to set the alimony for both of the parents. So even if the court does not have to stick to this table of recommended alimony high, usually the courts really stick to this table. So you can find this table online, and it's so-called recommended table of the alimony, and it's set according to the child's age. And there you see what should be the percentage from the net income of the other parent. So this table, this is in case you have one or two children that you have to pay alimony, and then the percentage goes lower if you have 3 or 4 or more children. So I didn't really copy paste it over here, but as you can see, the alimony could be quite a big portion share of the income of the parent. And usually the court really really wants to know the real income of the other parent. So I have experienced this many times that the court said, I'm not a tax office and I won't tell anyone. And just tell me the real incomes. Because of course, if you have businessmen, as a father, sometimes they really try to hide their income for taxes, but the courts really push them to tell the real income. Or as I have the international experience, many times I have cases where the father is from the country that you have no proof like of income. And of course, there's also no international treaty, and basically the Czech organs, they will have like no really draw to that other country, and then you wouldn't be able to even like ask someone for the father's tax statement. So sometimes they even go with a sworn statement, and if the other party doesn't really contradict this, then as a proof of the income, you can deliver a sworn statement. In some cases, if it's like a complicated international case, if it's a country like, let's say, I don't want to name any country, but there are many countries that you don't have the international treaty, and basically it won't work if you want to proceed with the alimony. Usually within, as I have experience within the EU, it usually works if you really want to proceed with alimony, but with the other countries, it's a little bit more complicated. So, let's go. So, the other very typical dispute when it comes to the children, and this is also for both married and unmarried parents, if there's a conflict, is a decision on child's significant matters. Yeah, I mean, this claim could be even started within married parents. Yeah, so of course, this could be only a very important and significant matter for the child. So as an example that the court usually stick to is like when it comes to residence, very typical thing is like if you have some visiting rights set and the parent that has the full custody or the most of the custody wants to move, let's say like 500 kilometers away, and the other parent of course contradicts it, because this will be quite disturbing the visiting rights and the custody rights of the other parent. So then when it comes to big medical interventions, like let's say surgery, and the parents don't agree with the child, with each other, or when it comes to choice of education or employment. Yeah, I have experienced like the parents even try to claim as a significant matter some decision on hobbies, some vacation spot. They want the court to put a ban on some vacation spots, or when it comes to just a usual vaccination. These are like the typical claims. So the court usually does not approve these claims, since it says, for instance, leisure activity is not significant matter. If there is between child's residence, or if what should choose there, then there should be a claim. So this is something that I often if it's the case of with Ukrainian clients, they often ask me if I have the full custody of a child and do I still need the father's permission to move or to choose the school. Yes. These significant matters of the child, according to the Czech law, should be decided by both parents, and if they don't agree, then you need to start with the claim. So, what are the rights of the child and how this is protected? So, in the proceedings before a court, the court always start, like the first thing that the court will do is appoint a guardian for the child, and that will be the Social and Legal Protection Authority, abbreviation OSPOD. So as I said before, this in case of agreed divorces, this will not be necessary, but still, if the court will see that the agreement on children is somehow must not be really benefited for children, it could still appoint this OSPOD. But as my experience from these even now agreed divorces, as we call them, so usually we have the first session. It's a very formal thing. And there is this OSPOD and the parents that have agreed on everything. And from my point of view, usually the OSPOD does not oppose anything. But in case of these agreements, and it goes right now, the parents, they either send some agreement to the court, or they have a proposal when they both agree and say, yes, we want the custody, alimony, and everything to be set like this. And the OSPOD usually is there, and he will also then in front of the court, you sign, the parents, they sign this agreement, and the OSPOD signs this too, as a representation of the children. So from my experience, it usually does not happen that the OSPOD will set or have some contra proposals to this, if the agreement is reasonable enough. And usually if you have a lawyer represented, then the agreement would be reasonable enough, because we would say, okay, the alimony should be set like this. The court would not agree to unreasonably low alimony and to unreasonable agreements, like if the child should pendle 500 kilometers every other weekend, that also would not benefit the child. So usually, as my experience as a lawyer, and I see that from the practice, the novelization will really reflect the practice, that within these agreed divorces, there will no longer be need for this officer to be representing the children. So, as a rule, if you have even the not agreed or agreed, also nowadays claims on regarding children's custody or alimony, it usually, as a rule, goes like this: that the Child Protection Office invites the parents and interviews the parents separately and then together, and also interviews the child. Sometimes it goes to the household, and sometimes you got the invitation and you go to the office. Of course, the child should be interviewed alone and according to its age, but even like children that are 5 years old, if they could speak for themselves, usually they spend some time alone with this officer. So what is a little bit what I see as positive for the novel, if I could say so, is that there will be no need to put more paperwork on this office in case of the agreed divorces. Because of course, what I see a little bit problematic for the office is that they have a immense workload. And of course, they are not, it's a part usually of a city hall, and there is not enough employees, and they don't only care for the cases where the parents don't agree on the custody, but they also do actions that are aimed at disrupted families, and also they protect children when they are in danger, and of course they also deal with children's delinquents. So what I have the impressions that the officials, they usually they see like that it's important, their work is important to protect the children that are really from disrupted families, or that really have some substantial troubles, but they are not really so happy to deal with these divorce cases. So maybe it will be better if there's no need for representation of the child. But of course, it's questionable how will be the right of the child protected, because there will be no one representing the child in case of the agreed divorce. So if usually the court should hear the child's opinion directly. So from judicative, we have set the age limit, like if they're 12 or older, the court is obliged to hear the child directly. But I have experienced even the children around 10 years of age are visiting the court, or the court can also set a different session. Then usually it's like this, that the judge visits the child in school. So let's say after the classes, the judge will will talk with the child, but that's really quite rare. Usually the child is invited, and at the time when the child talks with the I say talk, I don't say interrogate, because it's usually more like a talk. And at the time when the child is in the courtroom, not even the lawyers, not even the parents, or could be inside. So, and the judge investigates the opinion of the child. Mm-hmm. So. And now we can, I would ask if there are any questions to that. So I don't see any raised hands. So let's move to another part, and that's the matrimonial property. What is the matrimonial property? We have the definition, and I know from my colleague that it's quite similar to the definition in Ukrainian law. So that will be what belongs to the spouses, has a value, and it's not excluded from legal relations, and it's the spouses acquired during the marriage. So of course there are exemptions towards what is the matrimonial property. So as usual, personal items, things that were acquired as a gift, or inheritance, or compensation for non-pecuniary damage to one's natural rights, and things acquired through legal action relating to exclusive ownership, or as a compensation for damage, destruction, or loss for one's exclusive property. So, but what is part of the matrimonial property? So if you sell a property that was yours before the marriage and that is exclusively yours, then the price that you receive for it will not be part of the matrimonial property, unless you make it a part of the matrimonial property, but we're not going to talk about these. But if you have your exclusive apartment, and it's your exclusive apartment and you rent it during the marriage, then the income from the rent will be a part of matrimonial property. So this is quite a complicated matter, and this is very important within planning the divorce, or with planning of the client, of the strategy of the case, because of course usually the matrimonial property cases are could be in front of the court for years. like 5 years, or like 1 year is no time in these cases. Within 1 year, you usually get only one hearing, and within this hearing, you will just set what you all want to prove. And usually within these cases, there always going to be a real estate. So then there will be someone to put a price tag on the real estate, and that takes a long time. So these cases could take many years, and usually within the years, what is the biggest problem is that the client will no longer have assets for the fees. And because usually there's a big disparity, usually within the after the divorce, there will be the one who acquired money and the one who took care of the children. So usually after a couple of years, the one party will no longer have money to continue the proceeding, and then there will be an agreement. So how does it look like with the divorces? So you can go, I make here an overview. So now if you have disagreement on whether you want to get divorced, so you can file a lawsuit, and the court fee is 2,000 crowns. It will be 5,000 crowns from January. If you disagree on child's custody or alimony, if you are unmarried couple, so okay, there is a lawsuit, and it's not obligatory. You can still make an agreement out of court. And if you want to get divorced, you have to file a claim for to set children's custody, alimony, or visiting rights. And if you don't make an agreement regarding the division of matrimonial property, so there could be filed a claim within 3 years after the divorce. Yeah, so and then the court fee, it's quite interesting. It's 2,000. But if there is a real estate, so for every real estate, there's 5,000 more. And if we want to divide business, then the fee will be 15,000 more for the for a firm, so for a company. So you have to think twice. And say this to the client, because then even just starting the lawsuit could be quite costly. And of course, if you don't agree on the price of the property, then the price for having priced the property will be around 25,000. So, and this cost will be split between the parties. So that's it. So, but even now, if you had the agreement on the property division and on household division, you agreed on children's custody, and this agreement was approved by court, and you have agreement on the divorce, there's a possibility to claim for divorce without finding of the causes of the marriage breakdown. So in that case, you only need to have 2 claims. So for the children and for the divorce. And the only thing is that the agreement on the household and on the property has to have verified signatures. So it doesn't even have to be a notarial agreement. It only verified signatures are enough. So what will be there after a novelization starting next year will be that the court will not even have to interrogate the two spouses on the reasons of the breakdown of the marriage. So usually now it was quite formal, and at least one parent had to be there. Not parent, sorry. At least one spouse had to be present, and the court interrogates them. And usually there was agreed between the spouses. Let's say this formal reason, maybe disagreement on the future of our lives, some formal reason. But this formality will not be a must since next year. And as I see, the file number starts with C, the divorce file number. And even the matrimonial property claim starts with C, because I see it's like a plain civil matter. So one more thing, usually within these claims for the agreed divorce, until now, you have to claim that the spouses, it's not living together, but they don't have a common household for more than 6 months. It means, of course, with a hard financial situation, you can still technically live together. I maybe wrote it a little bit wrong, but still you doesn't have to have common household, yeah, for more than 6 months. So this will be no longer a precondition for an agreed divorce. So, and here's the division of the matrimonial property. So, as I said, the claim on matrimonial property could be submitted within 3 years after the legal force of the divorce. Otherwise, there will be a presumption. And within this presumption is that the tangible things belong to the person who has them, and the intangible go half and half. So this is usually, and now I will say something that's maybe not politically correct, but usually it is like this. The man made the most income in the marriage, is what I see from my practice, and he has all the financial all the finances are in his account, and the woman, she only is a part, like as the owner, as the matrimonial co-owner of the property. So she's only in the cadastre, but technically she cared for the children, and she doesn't have much money in her account. And of course, if you don't claim, then this will be, and if you don't have an agreement, this will be very unpleasant for that one client who didn't make the money. Usually it's the wife. So within this claim, you have to specify what is the amount that you want to be divided, or at least you have to specify banking accounts, or at least the banks where you think that the other spouse has the finances. So how it comes, how are the rules for the division? Basically 50-50, and most of the courts, they really want to go with the 50-50 rule, unless there's some exemptions. So what is the general rule is that income, the care for income has the same value as the care for the family. So if it's the classical split, the one is taking care for the children and maybe has a little income, and the other one is making like a lot of money, then it has the same value and the split is 50-50. So what should be taken into account if you aim for a disparity? So these could be negative circumstances in marriage. So usually if there was domestic violence, or if there's gambling of one of the spouse, or if one of the spouse was even sentenced to prison and couldn't really make any income for quite a long time to the matrimonial property. So in these cases, the court, if you ask for it, will think about the disparity. The other case is like if the wealth acquisition was extreme, and I heard from one judge of our highest court that we could think about 300 million crowns, which is quite a lot. So at this amount of matrimonial property, you could look if the income was really not really something that that has to start, like this source for the income has to start before the marriage. So a typical example is a sportsman, a very you can imagine a tennis player. So in order to make a big income as a tennis player, you have to train since childhood. And of course, you so this start for this income, even if the income could come mostly or exclusively within the marriage, for that you had to work since childhood, and at the time you were not married, so the other spouse could not help you with that income. So if it's a case like this, the court will of course, or should think itself about a disparity. But of course, if you don't claim for it and if you don't ask for it, the court usually will not think about the disparity in the cases. And then so-called diversions, we all know them quite well. Diversion is usually happens shortly before the divorce. And it happens sometimes by both of the spouses, but mostly with the spouse who had the highest income, or who is the owner of these banking accounts. It's the diversion is like that you send the money from the matrimonial property to some other account, some third person's account. And I guess we all know this so well, that usually the mother of one spouse becomes quite rich, or the brothers or other family members become quite rich before the divorce. And then you can also ask for disparity on the division of matrimonial property because of the diversion, but you have to prove it. And of course, there's also important to express to that other spouse that you didn't give the consent with the move of this property. So these are quite important matters, and it's always good to think twice about the case. The other questions that I got quite often in my practice is like the inputs from exclusive property to matrimonial property and vice versa. So as an example, I have a real estate acquired as an inheritance, and we made a reconstruction from matrimonial money from our incomes during the marriage. So that was done in, let's say, 2010, this reconstruction, and the divorce is nowadays. So This is quite wild because in the law there is in Czech law a so-called valorization rule, so that these infants should be priced according to the price at the time of the division. But we had a judicative for quite a long time of the highest court that the valorization rule cannot be used. But since this September, the Constitutional Court set a new judicative and said that the valorization rule applies. So, so this is quite new. The valorization rule applies. So, what is before I go to this family with international element, what would be the last part of this introductory lecture? So what is quite important is when you think about this division of patrimonial property and how to lead the case. So in Czech Republic, within the Czech claims, these matrimonial and divorce cases and even child's claims, children custody claims, you cannot, even in the matrimonial cases, you cannot ask for the compensation of the costs, even if you are the winning party. So basically, especially in the matrimonial property division cases, for the party that has no motivation to share, he can be motivated to prolong the proceedings as long as he wants, because there will be no compensation of the costs for the party even if you lose. So this goes for all the claims, for the child custody claim, for the divorce claim, and for the matrimonial division claim. So this is also quite important to know about Czech law if you deal with this family with international element. So I really here focus only on the Czech-Ukrainian treaty, because these two-state treaties, they should be applied first before some other international multilateral treaties. So, but as my experience, to apply to this treaty, you have to explain to the court that it has to be applied, because the courts really tend to, if you have a case regarding, let's say, a very typical case is the mother with the child is in Czech Republic and the father is in Ukraine or some other state, and typically in Ukraine, and how to apply the law. Usually the court, they don't even open this agreement. They just strictly go with the Czech law. So if you want to apply some rules regarding this international treaty or this two-state treaty, you really have to explain it. So what is a typical international element in a family case? It's that both the parents and also the child, the whole family, are foreign nationals and they are residing in the Czech Republic. Or one of the parents is a foreign national and all of them live in the Czech Republic. Or you have, no matter about the nationality, but the parents live in different states. Yeah. So typically Czech Republic and Ukraine. So first you need to determine the place of jurisdiction, and then you need to determine the applicable law. And that's why it's really important to know also a little bit and to have always a colleague from that other state to set a strategy for your client, because sometimes it's better to claim in one state and apply the law of the other states, and sometimes it's better to find some elements that might take your claim to the other state. So, as I said, this two-state treaty should be applied priorly before any other instruments in the areas, of course, that the treaty deals with. In some cases, and we will look at these later, there is a jurisdiction of the authorities of both states. So in these cases, and it's not some minor element. These cases are there's a quite high percentage of these cases. Sorry, so in this case, there's the least pendants rule. So first come, first serve. And that's why it's so important to know also a little bit about the other law, because you need to be quick sometimes. So the family law is in Articles 28 and from 28 till 36 of this treaty. And even for legal relations between parents and children, there is said this least pendants rule. And also there's a rule that in urgent cases, even if there's no authority of one contracting party, the authority of the other contracting party could take the provisional measures, so preliminary decisions. And these are the cases in order to protect minor child or child's property. And in this case, the authority should immediately inform in writing the judicial authority of the other contracting party. As for my experience, this did not work. I had already 2 cases, and we asked for the preliminary measure and stating this paragraph. So preliminary measure was set, but the other party was not informed at all. And even the court stated, according to this treaty, this court shall not decide in the matter, but since this is an urgent case, so I can say that there was like, in both cases, it was about child's visiting rights, and the preliminary measure was set, and but the rules were set, but the other party was not informed. Maybe what is also important, like from this practice, if you set visiting rights for cross-border visiting rights, you always have to define the time zone, when will be the time, or this preliminary measure will have no real appliance, because if you don't have set it exactly, then we all know that we cannot really proceed with this measure. So since in one measure the other party asked for it and they didn't set the time zone, we have a measure, and it's not valid really, because there's no time zone set. So when we look at this international legal relationship, we always have this element that make us the rules, how to set the applicable law and how to set the jurisdiction. So when it comes to personal and proprietary relations between the spouses, So the first criterion for applicable law is the common residence or the last common residence. And if there is no common residence, and there was never a common residence, then you have the first come, first serve rule. Yeah, and when it comes to the jurisdiction, then this is set according to the applicable law or the first come, first serve rule. So when it comes to the divorce, according to this treaty, the citizenship is the first criterion. If there are two citizenship, then you have the criterion of common residence as usual. But if you have two citizenships and domiciles in different states, then you have this first come, first served rule. And the jurisdiction of the sorry. So this is very important to look at what criterion you use and how are the relations between the criteria. And also, even for the jurisdiction, you have different criterions. And this is quite important to set this at the beginning. And when it comes to the children, then you have like completely the criterion of the applicable law is the first one is according to the child's residence. But if it's in child's interest, you can switch to the place of residence of the child. Yeah, and the jurisdiction could be established not by the typical criteria, but also by the court of divorce. So this means even if the child lives in other states, in Czech Republic, and the spouses, based on the criteria, claim for divorce in Ukraine, you can also claim for the alimony and the child custody in Ukraine based on the rule of the jurisdiction of the court of divorce. But of course, the other party could claim first based on child's residence in Czech Republic, even if the divorce was in Ukraine. So in these cases and in these criterions, it's really important for the client to be quick, because the criterions could set you to a high variety of how to set the case. And of course, like for the alimony, this is the usual criterion, like in every international treaty, is the place of residence, and the jurisdiction is also established according to the actual place of residence. And about the preliminary measures, I already talked before. So even if there's no jurisdiction of the authority, the preliminary measure could be set if it's in the child's interest. So, and that was all as for our short introduction. I hope I wasn't too long, and I'll be here if you have any questions.
About translate in Czech or Ukrainian.
Okay, so if there are no questions, I don't see any raised hands. Maybe you will have follow-up questions. You can always contact me on my email. And just a little heads up, I only speak Czech and English. I'll be here.
Maybe some Ukrainian lawyers may contact me.
Yeah, but you can also contact my colleague I can see here one question from Mrs. Orlova. If you involve the child welfare authorities, so I will read the question. If you involve the child welfare authorities, they can act in favor of the child's interest. Yes. Yes. And you can also make a proposal if even the judge usually as it was as it is until December 12th, the judge always set the Child Protection Authority as the representation of a child. It was a rule, like without this you couldn't even start the proceedings. But only in cases of this agreed divorce, there will be no need for the assistance of the Child Welfare Authority. But of course, if the judge will always evaluate the agreements, and in case the judge will think there's a need of this officer, he will appoint it. Any other question? So, okay, what is the usual lawyer fee for divorce and for division in simple case? From what sum? The usual divorce, the fees. Okay, this is quite hard to say. It usually most of my colleagues, we go with the hourly fees. So I would say it starts nowadays the hourly fee, 1 hour fee starts with 2,500. It could be like out of Prague at the smaller cities, and it goes up. And like simple case for divorce, it always really for instance, I had one divorce and I only had 2 hours there. There were no children and everything was set, and I only did revisions for the division of matrimonial property. So I only did revisions for that agreement, and then we excused ourselves, the attorneys, we excused ourselves to the court, and we excused our clients, and nobody even went to the court. So really, like, that was 2 hours, but that was the lowest. If I have practice in enforcement of Ukrainian court decision on alimony in Czech Republic, so I don't have the practice, but my colleague Olena has, so I will maybe invite her.
I think it may be like some article about this, not in measures.
No?
No.
So
I prepared some article.
Yeah, and how does it go? It
goes like Ukrainian court decision must be. Доброго дня, давайте українською. Так, є в нас практика визнання українських судових рішень стосовно стягнення аліментів. Воно йде до міського суду в Брині. Цей суд видає своє судове рішення щодо визнання українського судового рішення. Після цього це йде на екзекуцію до виконавця. Десь виконавець до 6 місяців це бере, розшукується платник і стягуються аліменти. Тобто є така практика, звертайтеся, я вважаю, що це, напевно, мусить бути окремою статтею чи публікацією, тому що тема цікава. Так, в 2 словах і трошки, сподіваюся, розкрила. Дякую за увагу.
So thanks to everyone. So as I said, if you have any follow-up questions or remarks, I would be happy if you share your practice. As I said, what I see as a main problem is that really the cooperation that is set in these international treaties between the authorities, it does not work so much, and the courts don't have much experience. So usually, and I see it, it's not only like Czech-Ukrainian relations, and it's like all the international cases. You go there with international elements, you start to building your arguments on some international treaties, international law, EU law, and the court doesn't want to deal with it. Because it's really like you don't have, it's not everyday practice, and it's quite hard to convince someone to use these international elements and to place an argumentation within these international treaties. So thank you for being here, for your attention, and